Good morning, everyone. Our esteemed colleagues and clients, thank you so much for joining us this morning for our webinar on the Expropriation Bill and the hot topic of expropriation with nil compensation or for no compensation. So we're glad that you've taken the time out to join us, and we hope that this session will be informative and really useful for you in your business. We are presenting this seminar together with Rosh Pinah Properties, and the presentation will be split up with a brief discussion from Rosh Pinah, Renee, followed by myself, dealing with landowners and developers and the implication of the bill on landowners and developers, followed by Claudette, who will be presenting on the implication of the bill for the financial institutions. And then we'll end off with a Q&A session. And so we trust that you will benefit from the session. And I'd like to now hand over to Renee just to kind of kick us off.
Morning, everyone. Thank you for joining us. Yes, what comes to mind when you ponder EWC? For me, as a company owner and a commercial property broker, a whole lot of questions. How will this new act affect our business and, most importantly, our clients? Companies in the listed property space, property funds, high net worth individuals with substantial property portfolios and land, property developers, foreign investors and funders, engineering firms that have massive infrastructure projects underway. What do I tell the interested foreign investor that is keen to invest in South Africa, but nervous about this new piece of legislation? What happens with my clients that have commercial property with no outstanding debt? So yeah, here to address all my questions and concerns, and perhaps yours as well, my esteemed colleagues from Cliff Decker Hofmeyer, Burton and Claudette. Thanks, Burton.
Thank you, Renee. So let's kick off. If we move on to the landowners and developers and the implication for them, and this would be across the board in terms of landowners. The bill doesn't distinguish between the types of landowners, it just refers simply to owners. And can I start off by saying that, initially when I saw the bill, I was quite pleasantly surprised because it doesn't, appear to be too invasive. I was a bit concerned that there would be an arbitrary right given to the state and to the expropriating authority to kind of carte blanche acquire land as and how they please. And that's not the case. There are a lot of protective measures in the bill, and so I think that the fears of my land suddenly being expropriated or developers' land being expropriated without compensation is unfounded and misplaced. One has to move past the political rhetoric and look at what the legislation potentially will say, and work from there, because we can get carried away with fear. And the starting point when looking at this bill is the legislation itself, and particularly the Constitution, because it's the Constitution that entrenches our rights as landowners and developers and for the financial institutions as well. And so it's important to start there before we move to the bill. And the Constitution section 25 is very clear. No one can have their property deprived and arbitrarily deprived. If you have property and you own property, you have a right to that property and that right to be protected. However, the Constitution does say that land can be expropriated for a public purpose and in the public interest. And so it's clear that expropriation is still allowed in terms of the Constitution, but it cannot be arbitrarily acquired, and there must be compensation. Section 25 provides for compensation. It doesn't say no compensation, unless you want to argue that, well, it's implicit that compensation could be null compensation, or as in previous cases that we've had where compensation is said to be in kind rather than in terms of monetary value. But compensation in and of itself applies or implies that it's monetary value and money that passes hands. And so one must start from that premise, and one must determine what that compensation is and whether that compensation is just an equitable, taking into account public interest versus the interest of the landowner. And so that's the premise on which one then moves to other legislation, such as the Expropriation Bill. And the bill, I must say, is largely in line with the principles as contained in the Constitution, and it's great to see that it's just not arbitrary. However, although the Constitution provides for expropriation with compensation, there is Section 36 of the Constitution that says that right to property can be limited in certain circumstances and where it's reasonable in a democratic society. And that section then sets out all of the principles as far as the limitation of those rights. And so that's kind of the backdrop to this bill. And as we move now to the bill itself, if you can move to the next slide, Karushka. The bill and ultimately the act may be subject to a constitutional challenge where it provides for compensation for null value. And I will get to that in due course. But the premise of the bill is that land is expropriated without value, and it's expropriated in those instances where it's in the public interest. And that public interest is limited based on the Constitution and based on the bill to three things. One is the nation's commitment to land reform, reforms to bring about equitable access to natural resources, and then also to redress the results of past racial discrimination. So at this stage, those are the only three instances where land is expropriated. And primarily to date, it's really been for land reform to make sure that land is distributed to those people that don't have land, or where people need to acquire access to natural resources, whether those are members of South Africa and part of the populace, or whether it is state organizations that particularly need land. And so that is the public interest. What I notice from the bill is that when one deals with expropriation, whether for value or without value, the challenge to that in the courts is not subject to a discussion or a challenge as to whether the public interest that is being pursued or the public purpose that is being pursued is open to challenge. It's really the value that is open to challenge, the compensation that is payable, and whether the state should pay something or whether they should pay nothing. And when I refer to the state, I'm referring to the expropriation authority as defined in the act, in the bill. And so it's a bit of a concern that that is not open to challenge and only the value that is paid for the property that is acquired. But the court has an inherent jurisdiction, and I suspect that one of the first challenges when someone's property is expropriated or is about to be expropriated, that may be the first challenge before one even deals with the value. And if we can then go to the next slide. There are a whole lot of definitions that are applicable, but for the sake of time, I'm not going to deal with all of those definitions. Safe to say that there isn't really an explicit definition that deals with the mortgage bondholder and therefore the bank's interests, but Claudette will deal with that quite extensively, and so I'll leave that to her. If we can move to the next slide. The general premise of the bill is that there is still a consultation or consensus that is to be reached with the landowner. So it's not what is feared, an arbitrary decision by the state to say, well, I need your land and I'm taking your land. There is the whole premise of the bill is that we will, as the state or the expropriating authority, we will consult with the owners with a view to reaching an agreement on the acquisition of the property on reasonable terms. And those reasonable terms include the value that I'm going to acquire your property for. And so I think the fears that have been circulated potentially in the public, primarily in the public, are not well founded. We can move to the next slide because I'd like to cut to the chase in terms of expropriation for no value and what they call in the act, the bill, null compensation. And so there's various categories or instances in which the expropriating authority can expropriate land for null value and for null compensation. What I'm a bit concerned about is that the preamble to the various categories says including but not limited to. And so that really opens the floodgates where the expropriating authority can say, well, I'm expropriating your land for this reason. It must be for a public purpose, it must be in the public interest, but I'm still expropriating your land for X, Y, and Z reason. And that's a bit of a concern for me, because there are not limited categories in which null compensation can be neatly slotted into. And so it's really a free-for-all as far as that's concerned. And that is one of the concerns for me in regard to the bill. I have other concerns where there is just a complete disregard for established property law, but I will get to that. So if we look at the categories that are provided for, there are not many in which null compensation is applicable. And I think for landowners, and particularly commercial property landowners, private landowners, whether that land is industrial, agricultural, residential, is that the first category says where the land is not being used and the owner's main purpose is not to develop the land or use it to generate income, but to benefit from appreciation of its market value. Now, most people acquire the land to develop the land. Whether you're a commercial property developer, industrial property developer, most people acquire land to develop it, whether that's to develop a shopping center or whatever it may be. And so this category doesn't really apply, because most people will develop the land. But sometimes people do buy land because it's in a particular area that may be well sought after in future, and they look to then at a later stage on-sell that land at a profit, at a premium, and make a lot of money that way. And those kind of properties are clearly at risk when it comes to this bill. However, we go back to the whole purpose of the legislation, and that is it in the public interest and for a public purpose? So that's kind of the first category. The second category really deals with where the organ of state has land. I'm not too concerned about that from a private property perspective. The next topic is, or the fourth category is where the market value of the land is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land. Now, that's not too much of a concern, because the state is really saying, well, we've helped you acquire that land and now we want the land back. The most important category for me after the first category that I mentioned is the category that deals with where the property is registered with the Deeds Registry Act and where an owner has abandoned the land by failing to exercise control over it. And that's also a concern for me, because it's very difficult to determine whether someone is exercising control over the land or not, particularly in those instances where the land is potentially just vacant land, land that is yet to be developed, and is simply earmarked for future purposes. How is this control to be exercised? And one would then have to look at the common law to determine whether control has in fact been exercised or is being exercised. And so I use the example of just a vacant piece of land in Gansbaai as an example, where someone may in the future develop a holiday home. And if no one is on the property for months and months, are we then exercising control over the property? Must I put security in place? How do I exercise that control? And so that may be the subject of dispute. But that said, the legislation does provide for disputes. It does provide for the court to ultimately determine any of those disputes if the parties are unable to reach an agreement. And so I think that there are sufficient protective measures in the bill to protect private property owners and developers. So that's really the crux portion of the legislation as far as I'm concerned, and I think that we do not need to be too concerned about these provisions. If we can then move on to the next slide. There are quite a few sections in the bill that are of concern for me, because they fly in the face of existing property law and property legislation. And the first is section 35A, read with section 91A. Now, section 35A says ownership of the property vests in the organ of state on the date of expropriation. It doesn't say that it vests or that the state acquires ownership on registration of the land or the property in the state, which is a big concern for me. Property law in terms of the Alienation of Land Act provides for ownership and therefore the risk and benefit in the property transferring on registration. And from that date, you then are entitled to the use of the land, the benefit of the land, etc. And this is a far cry from that piece of legislation, and it is a concern for me. Normally, when you have a transfer, there's a lot of rates, duties, transfer duties, charges that need to be paid to the municipality before transfer takes place, and this is not dealt with adequately in this bill. What it also provides for in Section 9 of the Act is that the effect of the expropriation is that the ownership of the property vests in the expropriating authority or in the person on whose behalf the property was expropriated on the date of expropriation. So the date of expropriation is not the transfer date. It's the date on which the state gives notice that it wants to expropriate the land. And that's way before the property is transferred to the state. And in fact, the bill does not deal extensively with transfer and registration of transfer, which is a further concern for me. And so that is an aspect that I believe that the bill really needs to address. It needs to be tightened up. It needs to, in fact, in my mind, link ownership with transfer because it will clarify a lot of issues. Let's just take one of the examples. The bill provides for notice of expropriation. So before I even give notice of expropriation, I have to give notice of the intention to expropriate. And in that notice, I give you an opportunity as the landowner to tell me or tell the state how much I want for that land. And the state then has an opportunity in the notice of intention to expropriate to respond and say, okay, I accept your offer, the value that you want for your land, or I reject it and I offer you a different amount. Then after that, the state then sends out a notice of expropriation to the landowner, and it's also published so that the world at large knows that this land is being expropriated. But that is the date on which the land is effectively expropriated and ownership is acquired, and the risk then passes to the state. But that's not the case. The bill provides later on in the bill that until the state takes possession of the property, they have no obligation in regard to rates and taxes, the surcharges in regard to electricity and water. That still has to be paid by the owner of the land, who was the owner, despite the fact that the state is effectively the owner. And so the whole ownership possession is not linked to transfer. Ownership has a particular date, which is the date of expropriation, and possession has its own separate date, which is notified in the notice of expropriation and may be different from the date of expropriation. And the charges in respect of that land also only takes place from possession. And so the state is not liable for rates and taxes from the date on which it is deemed to have ownership. It's a separate date in the notice of expropriation that says from this date I will be in possession of the land, and until such time as I take possession, I am not liable for the rates and taxes and the consumption charges. And that creates a huge difficulty for me. Let's play out a scenario. What happens if the state doesn't take possession of the land on the date that it says it will take possession? I remain as the owner of the land, although I'm not the owner anymore. I'm the person that's still in possession of the property. I remain liable for the rates and taxes and the consumption charges until such time as the state takes possession. And what happens if I vacated the land? If I vacated the land with a view to the state taking possession of the land, but the state doesn't take possession of the land, then who's liable for the rates and taxes? Because no one's in possession. It's vacant land. And so it's a lot easier if they just link ownership and possession to transfer. One of the things that is also provided for in the bill is urgent occupation or expropriation of land. And that's a separate issue that I will try and deal with if I have some time. But my big concern is that there is too much uncertainty as to the possession of the land, the ownership of the land, and the potential liabilities in regard to the land. So we'll have to see how it plays out, what kind of objections there are to the bill. At the moment, the bill is subject to public comment, and we'll have to see what the public comment is in regard to the bill. And hopefully this will ultimately be addressed. So we will have to wait and see how things unfold. Let's just move on to section 3.5c, and I think I've covered it to a certain extent, as well as with section 9.5. The section 3.5c provides that the relevant organ of state is liable for the fees, duties, and other charges which would have been payable by that organ of state in terms of any law if it had purchased that property. But the problem is that is only on possession, and it's not before possession. Section 9.5 says that the expropriated owner or expropriated holder who is in possession of the property remains entitled to the use, but then during that period he remains responsible for the payment of the rates and taxes. And that just creates such difficulty, as I've already alluded to, and hopefully they will sort that out. If we can move on to the next slide, Karishka. Now, going back to my point earlier where ownership is passed to the state and that's vested in the state at the date of the expropriation of the property. As soon as they give notice of expropriation, they're the owners. But the amount of compensation is open for determination by the court. Let's assume for the moment that the state and the owner cannot agree on the value for the property. And that value, just to pause there, is not an arbitrary value. The value needs to be justified both by the state and by the owner. And section 7 and 8 provide that for that. Is if you dispute the amount that's being offered by the state, you've got to give reasons why you say the amount is too low, or it'll never be too high, but why it is too low, and you would have to provide a valuation. But the bill provides that if there is a dispute, and we are unable to resolve the dispute as between the state and the landowner, then that must be referred to the court for determination. And the benefit of the bill is that determination is not necessarily at the instance of the property owner. The property owner has a right in terms of the bill to ask the state to institute legal proceedings for a determination of the correct compensation. But here's the difficulty. That court process may take several months or years to be finalized. But during that period, the state remains the owner. And I have no right in the property, and I then have to incur costs in litigation whilst I'm not the owner, and I may not be in possession of the property because the state is in possession by virtue of their notice. And so this creates untold difficulties and is a serious concern for me and needs to be dealt with. The next issue is section 9.1d, where the property remains subject to registered rights, but not a mortgage bond. So I'm leaving that to Claudette. Claudette will deal with that in the next session because that's also a problem in the Act. If we can just move on to the next slide. One of the last things that I want to deal with is just the exposure of the owner to non-disclosure. It's important that when you disclose your interest in the land and you make a price that you want for the land, you must disclose any unregistered rights. It's important if there is a lease over the property, if there's a usufruct over the property, if there's any other unregistered right, a fideicomissum, you need to inform the state of the fact that there is an unregistered right, because you as the landowner would be the only person that knows of an unregistered right, because for obvious reasons it wouldn't be reflected in the deeds office records, and you need to inform the state of that, because if you don't, it's a number one, it's a non-disclosure. And secondly, in terms of the bill, the state has the right to seek to recover from you any compensation that they may have to pay to an unregistered right holder. And that person that has rights in the land, and the state has to compensate them for that. The state, if they have to pay anything, may come back and say that we are holding you liable for that amount. And that may diminish the value that you ultimately receive from the land. So it's important when you are faced with expropriation to deal with all of the rights that are in the land. Can we move to the next slide? I just want to see if there's any other aspects that I can address. Yeah, as I said before, the challenge in regard to expropriation is really in regard to the amount and not in regard to public purpose or public interest. And the other issue, as I said earlier, section 21(8) of the bill says that a dispute in regard to the amount of compensation does not affect the operation of clause 9. And clause 9 or section 9 is the section that deals with the effect of expropriation and the fact that the ownership in the property vests in the state at that point in time and not on registration. So those are kind of the main concerns that I have in regard to the bill. I mean, there are a lot of issues that we could raise in regard to the bill, but I think that the bill in regard to compensation, and particularly compensation for null value, is not as scary as I initially thought it would be. I think it is certainly not arbitrary, and I think that there are sufficient protective mechanisms in the bill to protect landowners and developers, and I think it's not a situation of land simply being acquired on an arbitrary fashion and not being paid value for. I think that landowners and developers can rest easy in regard to this bill. That's it from me for now. I will see you again during the Q&A session. I'd like to hand over to Claudette to take us further in regard to banks and financial institutions and the effects of the bill on them.
Morning everyone, my name is Claudette Dutier and I'm a Senior Associate in the Dispute Resolution Department at Cliff Decker Hofmeyr. As Burton has advised, I'll be dealing with banks and other financial institutions in respect of the Expropriation Bill and the effects and concerns. There are a lot of rights that are founded in the bill itself. However, we need to see how financial institutions are specifically determined in the Expropriation Bill and how they are affected. I'll be dealing with 4 topics. Number 1, it is how are financial institutions addressed in the bill? More specifically, how are they defined? Secondly, current provisions affecting financial institutions. Thirdly, provisions which are cause for concern. And lastly, what do we want out of the bill in the future? We can go to the next slide. So first we need to turn to the definitions of the Expropriation Bill. Obviously, the definitions need to be read with the specific provisions of the bill, and this is our starting point. So it's quite prudent to mention that financial institutions are not specifically defined in the bill. And with specific reference to these provisions, we are looking at bondholders. And we need to look at different definitions because financial institutions are not specifically recognized in the bill. So we turn to the different definitions that are recorded in the bill, namely unregistered right holder. So as Burton has mentioned, unregistered right holders hold vast protection in accordance with the bill. This is before expropriation happens as well as after expropriation happens. And we are talking about tenancy, fideicommissums, and use of rights that are not registered rights. So we look at an expropriated holder. Does a financial institution be included in this definition? The definition means a holder of an unregistered right in the property. The next definition is holder of a right, means the holder of an unregistered right in the property. So unfortunately, financial institutions do not fall part of a holder of a right in terms of the Act, as these are defined as unregistered rights, such as tenancy. So we're focusing more on the registered side of bondholders, and we need to see and look further into the definitions if these are recorded. Can we go to the next slide? The next definition we need to have a look at is an owner. An owner is defined as where ownership of the property or right in question is registered, means a person in whose name such property or right is registered. Although the definition of owner includes a right, we don't find that financial institutions are included in the definition of an owner. And this is with specific reference with the intention of the Act as read with the other provisions. And we'll discuss this a little bit later on in the slides, specifically with reference to 18.1, where a bondholder as well as an expropriated owner are mentioned in an agreement. Now, if a bondholder is actually included in the definition of an owner, it simply doesn't make sense that that you would have an agreement with one party. But that we'll discuss a little bit later on in the slides. But our view is a financial institution is not going to be regarded as an owner. We move on to the definition registered, and obviously a bond is registered over a property, and it is defined as registered or recorded with the government office. So surely there's an inference that a registered right is going to be protected in this bill, and we need to explore that a little bit further. But specifically, we do not see bondholder or mortgage that is specifically defined in the definition clause. So let's just move on to the actual provisions of the expropriation bill in the next slide. So obviously when looking at the bill, you need to first look at the definitions, and then you need to have a look at the specific clauses read with the definitions. And before I approach section 5.1, and Burton has touched on this very briefly, is the Expropriation Act the Expropriation Bill has definitely tried to create a uniform process within which property is to be expropriated. This process starts with investigation and evaluation. Then you have a notice of intention to expropriate, and there's discussions in respect of compensation of the property. And then we move on to the notice of expropriation, and then the vesting of the ownership in respect of either the state or the person on whose behalf the property was expropriated. So what is very important is section 5.1 advises them that when the authority is considering expropriation, the existence of a registered and unregistered rights and the impact of such rights on the property need to be viewed. So this is very important. This does provide an obligation on the expropriating authority to view a registered right and therefore a bond over the property. But this is only in respect of the view of when they are seeing whether or not they should actually proceed with an expropriation. So between section 5.1 and section 8.1, there is a huge gap in legislation. So we move from the investigation and valuation side, where the authority has to definitely speak to the municipalities and the registered rights, the unregistered right holder and the owner of the property in respect of their valuation. But the bill is completely silent in respect of discussing same with financial institutions as bondholders on the properties. So when we get to section 8.1, this unfortunately is at the stage where the decision has already been made that the property is going to be expropriated. And as Burton says, there is a notice of expropriation with a specific date on that notice where expropriation takes place. Burton has also mentioned that the ownership then vests on the date of the expropriation. Now this leaves a huge gap in respect of the transfer of the property, and we've spoken very briefly on the practical consequence of that in respect of the Conveyancing and Deeds Office side of it, and the Alienation of Lands Act and Deeds Registries Act and how that fits in. Obviously, this hasn't been considered at all. When we move over to ownership, we look at section 9.1d, and this is when the alarm bells start ringing for financial institutions. So this is once expropriation has taken place and the ownership is either vesting in the state or alternatively with the person on whose behalf the state has expropriated certain property. Section 9.1d says the property remains subject to all registered rights in favour of third parties with the exception of a mortgage. And this is where the paragraph stops. So we are at a loss in respect of what happens in respect of a registered bond over the property. And the practical sense is there's no dealing with the registered bond over the property. and what happens to that bond. Is it cancelled? Is it negotiated? And is any further security considered when the bond is actually cancelled? So Section 91D has vast implications on financial institutions as a whole, and this specifically needs to be addressed. We can go to the next slide. So once the ownership has vested in the state or the person on whose behalf the land has been expropriated, we look at what happens to the title deed. The owner of the property that has been expropriated must deliver the title deed within 30 days of request, or alternatively need to provide the details of the person in whose possession the title deed is. So there's a certain inference that the banking institutions are acknowledged because a title deed would be in their possession if the property is actually bonded. If you look at Section 14.2b, the person referred to in A, which would be the banking institution, must deliver the title deed to the expropriating authority within 20 days of request. So this is obviously past and post expropriation, and ownership has already vested in either the state or the person on whose behalf the property has been expropriated. Also, it's completely silent in respect of the bond that is now registered on that title deed. We move on to Section 18, and this does provide some safety for the financial institutions, but we would definitely like to see that this is going to be expanded on. Section 18.1, when the property is immediately encumbered, the expropriating authority may not pay out any compensation to any such person other than the terms agreed upon between the expropriated owner and the mortgagee, after they have been provided with the underlying agreement. So this does give some safety to know that, they are recognizing bondholders in this respect, but we don't see how a bondholder is going to be paid out, and whether evaluation and compensation investigation is going to be made in respect of that bond, and whether that bond is actually going to be paid in full. We can move to the next slide. When we continue with Section 18.2, Section 18.2 provides an obligation on the bondholder as well as the owner to provide the underlying agreement to the expropriating authority. If this underlying agreement, which basically funds the bond, is not provided to the expropriating authority, it states that the expropriating authority may deposit the compensation money with the master. So we've moved from the agreement needs to be provided to the expropriating authority. However, we don't really see how and when compensation would be provided to the bondholder. And if the money is short, what happens then in respect of the bond that is registered over the property, and what kind of security that the expropriated owner can provide to the bondholder. What happens if there is a dispute in respect of the underlying agreement? Section 18.3 addresses this, that basically the compensation will be deposited with the master, and the parties may apply to the court for an order directing the master to pay out compensation accordingly. So what would happen then is the master would hold the money on behalf of either the expropriated owner or alternatively the bondholder, and then we would have to proceed to litigation to find out who is going to receive that compensation. So the financial institutions would have to approach a competent court for an order in this respect. We can change slides. Now we've looked at basically the definitions and some of the provisions which address financial institutions in not so many words. And what are the causes of concern? I think basically we've discussed quite a few causes of concern throughout this presentation, but definitely one that sticks out for me is the process of due diligence by the authority. There is a clear lack of definition of a financial institution and a clear recognition of a bondholder in respect of a property to be expropriated. Also, there's a complete lack of communication in respect of the expropriating authority with the financial institutions in respect of the process. How is an existing bond taken into account in valuing the property? Unfortunately, this is completely silent in respect of that. You see, the expropriating authority has an obligation to consult with the municipalities in respect of the property, but the bill is completely silent insofar as financial institutions are concerned with existing bonds. Section 5.1 recognizes that the expropriating authority needs to address a bond when determining whether a property should be expropriated, but that's where it stops. There's no evaluation, there's no investigation to how much the bond is over the property and whether the expropriated holder could actually pay the bond if the property is sold. Lastly, what happens to the bond when property has been expropriated? As we've addressed, the ownership vests in the authority, alternatively the person on whose behalf the authority has expropriated the property. But now what happens to the title deed and the bond once this ownership has vested? The transfer hasn't taken place and the bond hasn't been cancelled. So there's no protection for a bondholder other than Section 18, which is quite sparse. We would definitely like to see the bill expanding on that protection. And should a property be transferred without the debt having been extinguished, the bondholder has no security. This is not detailed in respect of the bill at all. So obviously, as the bill stands, the expropriated owner as well as the bondholder need to hold discussions in respect of this, but we need to see the inclusion of this in the expropriation bill. Please, can you turn to the next slide? Finally, what is lacking in the bill for financial institutions? What would we really like to see as bondholders over property to be expropriated? Number one, there needs to be a clear definition of a financial institution as a right holder. We see a large emphasis on unregistered right holders in respect of the bill. However, we would like to see the words mortgagee and mortgage bond and financial institution specifically defined. Secondly, there's a clear obligation on the expropriating authority to engage with many individuals, including unregistered right holders and the municipality, but we would like to see the expropriating authority to have an obligation to purposefully engage in the financial institutions, not after a notice of expropriation has already been issued, but rather beforehand in respect of the investigating and valuation portion, and also in respect of the negotiations for the compensation of the property to be expropriated. Lastly, we would like to see protection for bondholders. It's quite clear that the expropriation bill sets out quite a defined process in which the expropriating authority needs to address the bill and the expropriation of land. But we would like to see more on how financial institutions and the process involved in that. Specifically, conditions of the bond cancellation and when the bond is to be cancelled. And should the compensation not cover the debt, how is this debt to be dealt with in the future? And this can't just be determined between the parties, being the expropriated owner as well as the bondholder. We need to definitely define the process in the expropriation bill. So overall, I think there's a lot of questions that financial institutions need to ask and need to comment on the bill, but I think ultimately financial institutions need to be purposefully engaged by the authorities when they think that their property is going to be expropriated. And that's all from me. Burton, I think we're probably going to field questions now.
Thank you very much, Claudette and Burton. There are a couple of questions which have come through. One of them Burton, if I can ask you to answer this one. It relates to whether the actual decision of the state to expropriate can be challenged.
Burton, please unmute.
Sorry about that. Yes, thanks, Kalinka. That's a very interesting question. And it's one of the issues that is a concern for me, as I raised earlier, is that it's clear from the bill that the challenge is in regard to the amount of the compensation when expropriation takes place. And that's really what is sent to the courts for determination. What isn't sent to the courts expressly in the bill is the expropriation itself. Because expropriation invariably envisages that a landowner is deprived of his property when he or she doesn't want to sell the property, or the company doesn't want to sell the property. And they're happy to continue staying on the property, they're happy to continue using the property for their profits, and now the land is expropriated. And obviously the Section 25 of the Constitution allows that, subject to compensation. However, as I said earlier, public interest and public purpose determine whether expropriation can in fact take place. And if that public interest and public purpose is not served by the expropriation, then that should be challenged. It should be open to a landowner to challenge that aspect of the expropriation, and that should also be determined by a court. So yeah, I'm of the view that the court has the inherent jurisdiction to address that issue, and I suspect that that would probably be, in any subsequent litigation, the first claim by a landowner, and the alternative will be, well then, if you're only offering me X, that amount is insufficient for the following reasons, and then it'll be a normal dispute in regard to, is the value of the land and the improvements thereof sufficiently compensated or not.
Thank you, Burton. And then Claudette, I think this is a good one for you to sort of continue on in a discussion. There's an interesting comment that's been made in relation to the definition of property in terms of the bill, and that's that it covers both immovable and movable property. And then, of course, the comment that has been made is that the bill should possibly be limited in terms of this definition. Otherwise, movable property shares could also fall within this bill. If you've got some comments there.
Yes, definitely, Kalinka. And it goes back to what the definitions are. And I find that the definitions are very broad and they sparse in detail. So it does specifically reference to property and not immovable property. And this is quite scary because I think we definitely want to see it to only immovable property. When you think of the expropriation bill, you think of land. But in the bill itself, especially with one of the sections I covered, one of the clauses basically said that should the expropriated property be land, then the title deed needs to be handed over. So it is quite scary because, then it tends to lean to the fact that it may include property, it may be including movable property, and we would definitely like to see that definition being changed to immovable property. One consideration needs to be had is basically when they're expropriating land and there are tools and excavation units and different movables on that land, are those also going to be included in the expropriation? So I think between Burton and I, we've definitely shown there's a lot of questions at hand, and these definitely need to be addressed. And I think what the authority needs to do and what the government needs to do is focus on the definitions and streamline them to ensure that there's no qualms in respect of that.
Thank you, Claudette. Another question has come in terms of the actual expropriation process and that this takes place before transfer. And the question relates to whether the owner can then, between expropriation and transfer, actually dispose of that land, in other words, sell it. or whether there would be or there would be the requirement for an endorsement on the title deed. Burton, if I can ask you to speak to this particular question, please.
Yes. Thanks, Kalinka. Yeah, that is one of the difficulties, that I mentioned in regard to the bill, the fact that this ownership is not linked to a transfer. It does deal with transfer further on in the Act, I think around about section 19, somewhere around there, but it really deals with in regard to municipal rates. And so the difficulty is one could envisage a situation where an owner could potentially transfer the property before registration by the state. But obviously the state would then look to set aside the transfer because of the following reason. In terms of section 7 of the bill, when you receive a notice of intention to expropriate, you have to respond to that notice by one of them being, what amount am I prepared to accept for this land, inclusive of improvements, and also have I got a pending deal with a buyer? And that has to be disclosed. So it would be very difficult for an owner, and it would be ill-advised to, number one, advise, well, no, I don't have a pending deal, and then to go ahead and say, well, I'm now going to sell it, on the sly. It would make the state's job in setting aside a transfer a lot easier and obviously just costly, and they would then look to obviously seek damages against the owner for selling the property on the sly. So it's ill-advised to follow that route. It's rather to fight it on the basis of compensation. The further difficulty, and this is one of the challenges that I have with this bill, is that the state, in terms of section 14 of the bill, has a right to ask for the title deed within 30 days, on 30 days notice. I mean, it's just preposterous. We're now in dispute in regard to the value of compensation. We're going to court to determine the correct value, but in the meantime, you want my title deed, or I must tell you where the title deed is if it's subject to a mortgage bond, and the bank then has an obligation to hand over the title deed. And then effectively, you now the owner of this land, you own possession of the title deed. And if the transaction is subsequently set aside for whatever reason, I've now got to go back to the state and ask for the title deed. So it's just the wrong way around. It's putting the cart before the horse. And this really needs to be addressed. You cannot have a situation where you simply ignore the provisions of the Alienation of Land Act in regard to transfer of property, ownership in regard to property vesting prior to transfer. It creates difficulties with the municipality and rates and taxes. It just becomes an absolute mess. And if we could just follow well-entrenched property law, it will go a long way in allaying any fears. So the short answer is yes, you can go ahead and simply sell the property under the nose of the state, but you do so at your own risk. And I suspect that the state will provide for the endorsement of a title deed once ownership vests, and they will simply write a letter to the deeds office, the registrar of deeds, and say we are expropriating this land. The effective date of expropriation is the date of our notice of expropriation. And so as Claudette has said, there is so many gaps in this bill that need to be fixed, that need to be clarified. And so I would advise all landowners and financial institutions to in fact put their objections forward so that we can get a bill that deals with all of these issues. And so it creates a lot more certainty and a lot more protection, both for the state and more importantly for the landowners and the financial institutions.
Thank you, Burton. We'll deal with two final questions, and if I can shoot one of these directly back to you, it relates specifically to the state expropriating a piece of land due to it not being utilized or developed, and then if sometime later the state themselves do not develop this land or make use of it in public interest, the question is, does the owner then have the right to get his land back? Yeah, look, other common law principles will then apply, but my answer to that would be no, because there's no legislation that creates the right, or there is no right vested in the legislation that allows an owner to get the land back. Once it's been expropriated and ultimately transferred to the state, it becomes their land.
and they then are the owner of the land, and then your common law and other property legislation will apply, and it then becomes a willing buyer, willing seller, which is, it just seems very unjust, because the state expropriates the land for a public purpose, and then it just sits on their books and nothing happens with it, and the landowner then is prejudiced because the land that he wanted to use for whatever reason is no longer available to him. And so I think the easiest way to do that is to do some kind of development on the land, so that it's not vacant land that is just used for the purposes of gaining value and appreciation in the value of the land. But yeah, it is one of the difficulties, and it is, as the question has been posed, one of the grounds on which nil compensation can be paid.
Thank you, Burton. And Claudette, a final question for you before we close off today's session. It relates to bilateral trade agreements, and how will these be handled between South Africa and other foreign countries with regard to foreign owners of property?
Well, Kalinka, if you look at the bill, obviously it's silent in respect of foreign owners. Foreign owners will be treated the same as local owners. What happens is the authority basically looks at a piece of land, say there's a claim over it, and then determines whether or not they should proceed with a notice of intention to expropriate. Whether or not a consideration is going to be had, whether or not that land is owned by a foreign owner or a local owner, I'm not sure whether the authority is actually going to take any attention to see whether it's a foreign owner or not, because then that basically discriminates between local owners as well as foreign owners. But I think we'll need to see how the authority actually deals with that at a later stage. But as it stands at now, the expropriation bill, it applies the same between foreign as well as local owners. And I think it will probably continue to do that. I know investors will probably not like that, and I think it will probably be quite bad for business, especially if land is expropriated in respect of foreign ownership. I don't think that's going to do well for our country, but we'll have to see how the authority actually deals with that at a later stage.
Thank you very much, Claudette. Burton, do you have any comments on this last question?
Yeah, I agree with Claudette in terms of the point of view that she carried across, which is correct. I think the other issue that is potentially going to be difficult for the state is really notice of expropriation, because they would have to notify foreign owners, and the process that they would have to follow in regard to that notification may become problematic. The Section 7 and Section 8 deals with notice, and that publishing of that notice is not really specified in terms of how one would deal with foreign owners and how that publication would come to their knowledge. So those are kind of practical difficulties, and I think that in order to avoid any doubt in regard to bilateral agreements and property owned by foreign investors, that should be addressed in the bill and in the ultimate act in due course. Obviously, one has to, first look at it from the perspective of foreign investment within the Republic of South Africa, and the impact that this bill can have on foreign investment, and whether it will create nervousness. The mere fact that you can expropriate land, never mind whether it's for value or for nil value, creates nervousness, because foreign investors invest in land in the Republic of South Africa for profit. And sometimes not for profit if they're a non-profit organization that has community responsibility in mind, but they want to have certainty in regard to achieving their objectives. And as soon as their land is open for expropriation, whether for value or not, it creates a sense of nervousness because they can't achieve their objectives. And so they will then look for another land or another country in which they can invest to achieve their purposes. So it is a concern, and it is one of the concerns. But at least we have, in terms of the bill, not an arbitrary, I'm going to acquire land, irrespective of what landowners and financial institutions have to say. I think that's it, Kalinka, and I think we can close off. If I can just end off by saying thanks so much for attending. Thank you for your time. I know we're ending the year. It's been a long year, and a year that no one will ever forget. But thank you so much for attending, and yeah, we look forward to hearing from you and answering any further questions that you may have. Thank you so much and have a great day.